Okay, our next case is Maye versus State of Florida, number 2023-1184.
Good morning, Your Honors. May it please the Court, my name is William Pinnell, and along with attorneys Eric Service and Laura Shapiro, I represent the petitioner, Marcus Maye, in this case. I'd like to reserve 5 minutes of my time for rebuttal. At issue today is whether the Fifth and Sixth Amendments to the United States Constitution permit a defendant's minimum sentence of 67 months in prison to be increased to a mandatory sentence of life in prison based solely on findings of fact made by a judge by a preponderance of the evidence. Likewise, pursuant to the PRR statute, can a defendant's maximum sentence be increased based solely on findings of fact made by a judge by preponderance of the evidence?
Can I ask you this? What was the maximum sentence that the defendant was exposed to without the PRR finding?
The maximum sentence was life in prison.
Okay, so we got the same maximum. One's a mandatory under the PRR, but he was exposed to the life sentence without the finding. I understand.
So I would suggest that it's not
that's correct. I'm understanding that correctly. So he's exposed to life either way, with or without the finding.
So I would suggest that the life sentence after the PR is a higher mandatory sentence because subsection B of the statute, 775-0829B, specifically says that a defendant will not be eligible for parole, controlled release, or any form of early release. Then they must serve 100% of the court-imposed statute. So if there was another statute that gave someone with a life sentence the ability to have early release, this would preclude it. So it is, in our position,
do we know that there was any such applicable provision that would have, which the defendant here would have been eligible?
I'm not aware of any, but if there was another statute.
Well, if you were aware of one, if there was one, you'd probably be aware of it, wouldn't you?
I would hope so.
Okay. So really none of that affects the defendant here.
I think when we're talking about constitutionality of the statute on its face, I think we need to address whether the statute at issue also increases the maximum sentence. For example, on an F1, a first-degree felony, we would have a...
Well, the constitutionality of the statute on its face, that's an issue here. Obviously, that's kind of the issue that brought it to us. But that's kind of gone away to a significant extent because the state's now conceding that this recent U.S. Supreme Court case has decided that adversely to the position of the state previously, okay? But we've got other issues here because this is in the post-conviction context, which were not developed here. So I'm just, but I understand it's just as this is an interesting context for this issue to come up in, and the kind of the lay of the land's been changed on the underlying issue because of this recent U.S. Supreme Court case, which the state has conceded on. But there's some other issues that might get in the way of relief coming to your client.
I understand, and it's our position that the court is correct and the state is correct to concede that the U.S. Supreme Court and the decisions of this court established in our position that the statute's unconstitutional on its face.
Can you address just the cognizability of this error in the context of 3800A? So we have Martinez and we have Plot. The state points to Martinez because a lien errors, at least in Hughes, for example, classified as a process error. We have Plot, which it doesn't directly address head-on how to square a lien error as a process error with the rest of our jurisprudence that suggests that a process error is better suited for a 3850.
So the Martinez case talks about a lack of notice in the information and it being defective, and the Plot case and subsequent cases, including the Robinson case from the first DCA and Judge Eisnagel's recent concurrence in Denson, find that Plot is the appropriate case and it is cognizable under a 3800A motion if you're addressing the substantive issue of whether the judge or the jury made the required findings as opposed to an alleged defect in the information. And I think that's a reasonable line for the court to established.
How do you harmonize Martinez and plot?
For the reasons I just said.
Just the notice issue.
It's a notice issue and they find that to be this court found that to be a procedural issue, and the actual substantive Apprendi issue where the jury does not make the finding beyond a reasonable doubt has been found to be substantive, and that's the distinction.
So we would have to, because we also have Hughes, and Hughes came up in retroactivity, obviously, but Hughes classifies Apprendi at least as process. Is there a way to square all three of those?
There's not. I think Hughes is wrongly decided, and the court should recede from that based on its decision in Poole. I think if you read Hughes and you read Erlinger, they're inconsistent. Hughes is still talking about sentencing factors and still talking about minimum mandatories being okay. I think that the case law has evolved. The U.S. Supreme Court has more fully explained what Apprendi means, and in light of the significant discussion of the history of the Sixth Amendment and what the framers intended in Erlinger, it's now obvious, in our opinion, that this right is a substantive right that's entitled to retroactive application, and Hughes is outdated given the current.
But none of the U.S. Supreme Court cases
Court.
Find that this is retroactive, right?
I'm sorry?
I mean, is there, can you point us to a case that said Apprendi is retroactive?
Well, I would point this court to
Erlinger?
There's no, as far as I can tell, there's no cases that have come out since Erlinger was addressed that address the retroactivity of Erlinger. There may be a stray case from out of state or a federal case.
What about Apprendi, Aline?
Well, this court had previously found Apprendi to be not retroactive, but I would point this court to the Mosley decision.
What's the U.S. Supreme Court said about that?
The U.S. Supreme Court has so far said that Apprendi is not retroactive.
Yeah. Okay, they've been saying that quite a while.
So can we kind of go to first principles on this, because let's say we want some harmony between Plott and Hughes and Martinez.
Sure.
Looks like either Plott or Hughes has to fall to seek harmony, right? You'd agree. So if we start with a legal sentences, we've precluded those that are errors in the process. If this is a sentence that could be imposed legally, it's subject to harmless error, it's subject to preservation. How is that not a process error? So in other words, if the process had been followed, this sentence would be illegal. The process was not followed, therefore it is a sentencing error or an error in the judgment. How do we elevate that to something that we've classified as a legal sentence? In other words, sentences that, under no facts and circumstances would be able to be imposed under the law.
Well, I point to the court's recent decision in a Dettel case where it acknowledges that the Apprendi rule is, quote, in some sense procedural, but also of a substantive character because it addresses what the state must to prove its case, and beyond a reasonable doubt is the standard. So we believe that beyond the reasonable doubt standard is a substantive component, and Dettel provides authority for the fact that this is a substantive rule.
But that wasn't argued here. That's not part of this case. That's not what the case was decided on. There's nothing about that. It's all about the finding, not the burden that's on the state. Right? I'm correct in reading Maye, the opinion in Maye.
I certainly would agree with Your Honor, because the court didn't get to retroactivity or a remedy because they denied relief. So they said that it was appropriate for the trial judge to make the finding by preponderance of the evidence, based on the Simmons case from the 5th DCA, which held that the statute was constitutional on its face and as applied. So no court in this case has addressed retroactivity. As of this point, it's our position, given the change in landscape that you've discussed, and that.
But I guess go back to, and maybe I'm missing your train of thought here, but the decision in Maye, the decision on review here, does not address the burden of proof. Isn't that correct? I mean, you're talking about that as using that as something that puts us in some kind of different category, but that's not even talked about here, I don't think. It's all about the factual determinations required to support the PRR designation were made by the judge, not the jury.
So our position is that the May case relies almost entirely on the Simmons decision from the 5th DCA, and the 5th DCA addresses both the jury and judge finding and the beyond a reasonable doubt standard.
How does it rely almost exclusively on Simmons? That's just one case in a string cite, and it's cited for the general proposition that establishing the date of release from prison is simply a ministerial act. Do you see another citation to Simmons that I'm missing?
You're correct. The trial judge below relied entirely on Simmons, so I misspoke. The trial judge below said they were bound by Simmons and cited, I believe there's a parenthetical in the trial court's order saying that Simmons found the statute to be constitutional on its face and as applied. It's our point it's our position that once an Apprendi issue is raised, it's readily apparent that both the issue of who makes the decision, the judge or the jury, and what quantum of proof is necessary is implicated. Just because, and we now know, as the state conceded and as Ergenlinger states, that any kind of enhancement like this needs to be proven to a jury beyond a reasonable doubt.
I'm sorry to interrupt you. Could you try to, and you're getting sort of bounced around here, so it's not totally your fault, but could you please directly respond to Justice Sasso's question about whether, I think part of her question was, is 3800, is that just inconsistent with any type of claim that would have to be reviewed under a harmless error standard?
And with preservation requirements.
Meaning that it's not fundamental error, is that your point? I mean, but start with the harmless error thing, because that seems like the point of the 3800 rule is you're supposed to be able to just look at the face of the paper in front of you, and then you can kind of, it's a yes or no, is it legal or illegal, and there's a remedy. It seems like here you can't do that because of the harmless error issue. And so if one of the things that's floating around here is trying to harmonize, if we have inconsistent precedents and we've got to choose which path kind of makes more sense given the rule and what it's for, if you could just directly respond to the idea that if it's subject to harmless error analysis, that it basically doesn't fit within the 3.800 framework.
Well, I guess I disagree. So under plot, the remedy in plot was to remand to the DCA to conduct a harmless error analysis, and then once they determined that the error not to be harmless, to remand the case for resentencing.
Is there any other illegal sentence that you can think of that's subject to harmless error analysis? I haven't been able to think of one.
Not as I'm sitting here, but I will think of one for rebuttal.
What prevents this from being more appropriately a 3850?
It's an illegal sentence that clearly contradicts constitutional provisions, and the long-standing tradition of this court and precedent of this court it is something that can be determined by reviewing the court file.
But if
you don't need to be evidence or testimony.
If there was harmless error, is it really an illegal sentence?
Well, first of all, we don't think harmless error analysis is appropriate if the statute's unconstitutional on its face. We think the statute should be voided in its entirety, and then there is no harmless error review. The statute does not exist then, and he should be sentenced pursuant to the criminal punishment code. So I think that's the most straightforward and the correct answer. Apprendi errors.
I don't think we've handled that in similar context in that way. I mean, I think there's a lot of precedent, or at least some precedents that would defeat that argument, because this is one context, but these issues about what the judge has to do as opposed to the jury's come up elsewhere, and we have not decided those cases in a way that's consistent with what you're saying, I don't think.
So if the statute's unconstitutional on its face because it requires the court to make the decision and the decision to be made by a preponderance, the statute's unconstitutional on its face, and like this court did in Heggs, it should invalidate the statute and then require resentencing according to the valid statutes that remain.
If there's a constitutional error, but why in a case where evidence was admitted, it's beyond a reasonable doubt that any jury that would have considered that evidence would have found the defendant to be a PRR under the appropriate
Because if there's no, go ahead, I'm sorry.
Yeah, so I mean, that is harmless error analysis.
I understand, but I don't think harmless error analysis applies if the statute is unconstitutional as applied. And I point the court to Judge Maker's concurrence in the Woods decision, where he says the whole statute should fall. And
well, in terms of remedy, but that I think harmless error and remedy are different.
Well, I guess
if it's not harmless error, then you got to go to remedy. And
I'm having a tough time understanding if the statute is unconstitutional and cannot be applied constitutionally in any manner. Well,
the harm of an unconstitutional statute is an unconstitutional sentence because of a constitutional error. It's not the fact that an unconstitutional statute exists, right? There has to be some harm. And if that error is harmless because the protections that are afforded by the Constitution were in fact honored in that case from a factual standpoint, I don't understand.
So it's our position that the statute requires an apprendi error because it requires preponderance of the evidence and requires the judge to make the decision. So there's no constitutional way to apply that, and the only remedy for that is not to. Well,
but there is a constitutional way to apply it. The statute is subject to the requirements of the Constitution. If the burden of proof in the statute is wrong, we apply the constitutionally required burden of proof. That seems to be a simple way to solve the issue without causing a disruption in the whole system of justice.
So I don't think the remedy is to violate the separation of powers and rewrite the statute, and that's what the court is suggesting.
It's not rewriting the statute. It is causing the statute to conform to the requirements of the Constitution rather than disrupting the system. But again, you have your position, and I don't think it's consistent with our precedent.
Well, I ask you a related question about that.
Is it 3 minutes?
Go ahead. Go ahead.
Entire time left, or
we'll give you more time.
Okay.
Could you respond to the state's argument that really the only facial problem with the statute is the burden of proof, that it doesn't? I understand that it's it has been applied. Apparently, it's been applied as the judge making the decision, but the statute doesn't explicitly say that the judge is the one who should be making the decision.
I think a fair reading of the statute makes it clear. It's a subsection 3 of 775-082-9A3 says, if the state attorney determines that the defendant is PRR, the state attorney may seek to have the court sentence the defendant as a prison release offender. Upon proof from the state attorney that establishes by a preponderance of the evidence, the resulting sentences apply. I think when you put those two sentences together, it's readily apparent that the legislator intended that a judge make the finding.
But if we wanted to let's say that it didn't have the standard of proof problem, and we have all the canons about trying to read things as being constitutional. I mean, obviously the judge is going to be the one sentencing, but it doesn't on its face say who has to make the finding.
Well, I respectfully disagree. I think that the way it reads, it indicates it should be the court. We know that the legislature knows how to say when they want the jury to make the finding. They've done that in the capital sentencing scheme, pre-Hearst and post-Hearst. Pre-Hearst, they said the jury made recommendations, and they used the word jury in the statute. And post-Hearst, they lay out what findings the jury has to make. And the word jury appears, not solely the word court. So I think it's reasonable to conclude that the statute as written requires the judge to make the finding. Back to Justice Kennedy's question, Monago, in Justice Lawson's opinion, talks about the court's ability to effectuate remedies and imply and they changed the burden of proof, and they changed from the judge to the jury in that case. But he says, and the court says in that case, that that's a rare occurrence, and there's a separation of powers issue. And I think, and he says that should only be used when we're addressing, quote, new problems that the legislator has not had time to react to. This isn't a new problem.
Well,
Apprendi was decided 24 years ago.
How old is the statute that your client was sentenced under?
It's from 1997.
Okay, so, but we're talking about that statute, 97, the 97 statute. That's what's at issue in this case, correct?
Correct, and it's not a new problem.
Well, how
so the standard that Justice Lawson indicated was...
But it's got to be what you would have expected the legislature to do in '97, not now.
Well, in the Monego case, in a footnote, the court also says that the legislator is on notice of Supreme Court precedent.
Well, here it's Erlinger is the relevant precedent, right?
I disagree. I think the relevant precedent starts with Apprendi.
The Supreme Court itself doesn't even agree internally about the whole prior conviction thing, and this is just sort of a subsidiary issue, aspect of that.
Actually, they do agree. They say in Erlinger that they've discussed how narrow that exception is. It's the bare fact of a prior conviction, and they say we've said this to the point of, quote, downright tedium, and they lay out from Apprendi to Ring to Alany all the way through to Erlinger. So there is an internal inconsistency. The internal inconsistency is whether that exception should be destroyed completely and removed completely. They are 100% in lockstep.
Well, three of them disagree.
Okay. So the majority is in lockstep that since Apprendi, they have clearly delineated this as a narrow exception that only applies to the fact of a prior conviction, not a related fact, not a ministerial fact, not something that's a derivative fact. It's only the fact of the prior conviction. And the reason for that is simple, is because that prior conviction has already been subject to proof beyond a reasonable doubt and a finding of a jury. So you already have the protections that the Constitution requires.
Okay, you can have 30 seconds to finish up.
So it's our position that the statute is unconstitutional on its face, that the sole remedy is to remand for resentencing pursuant to the Criminal Punishment Code, because that would remain intact. The PRR statute would not.
Okay, thanks. And you can add 3 minutes for rebuttal. Thanks.
Mr. Chief Justice, and may it please the court, at the outset, we view it as a bit of an inconvenient truth that the court lacks jurisdiction in this case. Now, that hasn't come up today, but that is our view.
Yeah, let's talk about that.
Yeah.
So let's hear your spiel on that.
Sure. So I'm sensing some skepticism then.
No, I mean, before we ask questions, I mean, you have the floor,
yes.
So let's hear it.
Certainly. So let me say, first, we're actually quite eager to get answers on a couple of the merits questions in this case, in particular, the propriety of decades after the fact, and also the retroactivity point. But the reason that we've raised the jurisdictional point is because, post 1980, the court's jurisdiction over express declaration cases has to turn on a district court decision that actually expresses the view that the statute itself is constitutional. Now, the lower court could have done that here if it had acknowledged that there is a provision of the PRR Act, sub 9A3.
Let's just engage with the text of the decision below.
Sure.
Maye argues, as he did in the trial court proceeding, that his life sentence as a prison release reoffender is unconstitutional. We reject this argument because the date a defendant was released from prison or jail and the nature of the qualifying offense are ministerial in nature and thus do not require jury findings. If the court expressly rejects an argument that the statute or the sentence pursuant to the statute is unconstitutional, how can the law be anything else in this district that the statute is constitutional? I mean, if you were a practitioner in the 6th DCA, how would you get around this case in arguing that the statute was unconstitutional?
Yeah, I think it would be difficult, but I think that argument sounds in the old inherency doctrine. So just to give you an example, there are sentencing enhancement statutes. The 1020 life statute under 775087 is one of them that implicates Apprendi only insofar as what the judge does at trial. There's no actual legislative text that says, here's the burden of proof, here's which decision maker.
And that could be the case, but I think when you read it in context, and so I guess my concern is that I'm concerned that your argument is a magic words argument, because the court clearly did not reject that here. The court categorically rejected the unconstitutional sentence argument because of this ministerial exception. To me, that's a statement that I understand it's a different constitutional argument than you think is the constitutional infirmity with the statute, but it is still a decision by this court that the statute is constitutional for the reason that they were caught up on?
I think at the end of the day, downstream, it has the effect in a roundabout way of saying that there's not a constitutional defect with the statute, but the constitutional defect is in a provision of the statute that is not cited, it's not quoted, it's not otherwise referenced. And so the reason that I brought up the 1020 life statute is because if a similar challenge, the DCA could have said the identical thing about the 1020 life statute, subbing in instead of the PRR release date finding, whether a weapon was carried or used in the commission of the crime, but that wouldn't actually implicate the statute itself, because there's nothing in that statute that violates Elaine and Apprendi. It's what the trial judge does in a case like that that implicates the Sixth Amendment. So for all you know, looking at the four corners of this opinion, which is what you do when you review your jurisdiction, that's what happened in this case. But again, I don't want to die on this hill.
Have we ever said that the four corners, and I understand that's an important principle when there's issues about facts that aren't, when we're looking for conflicts and everything, but when the court explicitly says that we agree with the reasoning of such and such case and then cites it and has the parenthetical, do you think that we should apply the four corners so strictly that we wouldn't even give the court the benefit of essentially incorporating the reasoning that it's saying that it agrees with?
Chief Justice Muniz, I think the rule that we laid out is if you have to draw some inferences about what the district court thought about the statute itself by resorting to, say, reading the Simmons case, which is cited in the opinion, I think that goes beyond
Tell you
the
what,
four
Mr.
corners.
Solicitor General, if you promise never to cite this case in the 6th District on behalf of the state for the proposition that the statute is constitutional, then we'll take this jurisdictional argument more seriously. But I have a feeling that this is the first case you would cite the next time someone made the same claim in the 6th. You would say, this court has already found the statute to be constitutional. See Maye.
Well, we obviously
he's
review on the
admitting
merits,
that they're wrong.
Right. So, but as I've said, I don't want to die on this hill. We just feel as though we have to make this argument because we want to be fair dealers with the court about the scope of its jurisdiction.
Mr. Justice, I have a question for you. All right. So, assume we all agree that we have jurisdiction. We're going to exercise the jurisdiction. Why should we not grant the relief as requested by the appellant?
Sure. So I'll start with the 3800A bar here. There have been a lot of questions about, say, how to harmonize the plot case with some of the court's other decisions. I think that's very hard to do, but I give you a sort of narrow path to that result that wouldn't require overruling plot in a future case. But Justice Sasso, to your point about is it just Hughes that would have to be overruled, it's actually not just Hughes. It's every time this court has done a retroactivity analysis in an Apprendi progeny case, it has effectively held that it's not Apprendi is not a substantive rule. So because in all of these cases, including Mosley, the court is looking at the second prong of the Witt test. The first prong is, well, is it a substantive rule? And the court has never found that it was a substantive rule. It didn't place beyond the power of the state the ability to impose the punishment. It's always done it on fundamental significance, which is a finding that Apprendi is a rule of procedure, which is precisely what the U.S. Supreme Court said in Truro versus Summerlin. So you'd really have to be overruling all of those cases, and there's no good reason.
Overruling all those to keep plot.
To keep plot, precisely.
Or,
what if plot was considered not the best route, and we looked at a different route for these errors to be brought, such as 3850?
Yeah, I think that's exactly the route that the court should go. I think that's the most principled way to look at this. I would offer one caveat on the 3850 point, which is that we have held out 3850 as the appropriate procedural mechanism for raising these in post-conviction, but we still believe that there needs to be a contemporaneous objection at trial. The third DCA has recognized that in a case called Lutton, and I think that makes all the sense in the world, because otherwise you permit a defendant not one jury trial, but really two jury trials. A defendant can sandbag the state in the trial court by sitting silent at trial, not requesting a jury finding as to the disputed element, which may not even be disputed, and then later impose additional procedural hurdles on the state and the need to re-impanel a jury. So we think that defendants should be objecting contemporaneously when this comes up. Now, if you don't have to say, by the way, that plot is incorrect to get to our result in this case. There is this way to distinguish plot, which is that, although I think it's incorrect because plot should have just said what Martinez said, which is that this is procedural. You can't raise an age-old procedural claim with 3000A. But at least that case dealt with Blakely, which dealt with the statutory maximum. So this court has sometimes said that a sentence in excess of the statutory maximum is illegal. And, you know, in a sense,
and I understand that from the brief, but I have a hard time accepting that that would create any sort of coherency when an Alene error is an Apprendi error according to the United States Supreme Court because it increases the penalty. So it would just seem to be splicing for the purpose of keeping a case and still maintaining the
well, look, I think that's right. I mean, I think that's totally right. The most principled view is that plot is incorrect. But, you know, if the court wanted to, it could say, look, we don't have to take that on here because it's a little bit of a different matter, and you could sort of get to the right answer without having to overrule.
I've never seen this level of wizardry applied by your office to try to get us to keep one of our precedents. It's usually just, you know, recede.
Well, there may be a future case where we put that question to you, a future Apprendi case. We just don't think it's necessary here.
Can I ask you to respond to the argument just on the issue of whether, assuming plot doesn't exist, whether or not an Alene error should be cognizable as a legal sentence? I think the argument is that it's a vindication of a substantive constitutional right. For that reason, it's substantive and shouldn't be processed for purpose of a legal sentence.
So we think that that's just incorrect, and the precedents say that that's incorrect, including Shapiro from the U.S. Supreme Court. So the dichotomy here in the criminal context, something is substantive if it takes away, a rule is substantive if it bans the state from imposing liability or imposing a particular penalty. Everything else is procedure. So the steps along the way, including, you know, this court has said in Hughes and the Supreme Court has said, deciding which decision maker has to make a factual finding, that's all procedural. So under that, you know, that very old, well-settled dichotomy, I think that this is a rather easy case on whether it's substantive or procedural. Now, I know that there's some language in Dettel that's dicta that describes Mosley and says that, well, you know, Hearst is in some sense substantive, but I think that is, you know, that was not the question in the Dettel case, and I think looking more broadly at the court's precedents, it's clear that this is, you know, procedural in the relevant sense. Now, the reason that we think Martinez draws a good line between substance and procedure you can't do with 3800A, substance you can, is because 3800A, when the court drafted that rule, it was sort of looking at a compromise between, on the one hand, fairness to defendants, we don't want you serving time for an illegal sentence, but also respecting the state's critical finality interests. And this case sort of lays bare the problem for us, because it's 2 decades later, the defendant is coming here and he's saying, I have a problem with the procedure used back in 2003, and as a result, I want an entirely new full de novo resentencing. Now, that's going to be very difficult for the state to do, not necessarily because we have to prove the PRR fact, that's ministerial, that's pretty easy, but we would potentially have to recreate for the judge the facts of the crime. We may not have witnesses available, we may not have documents available, and not just that, if 3800A can be used in this manner, it's not just Mr. Maye's case and a handful of other cases, it's the 7,100 Florida inmates currently serving time under PRR minimum mandatory sentences, and perhaps some other sentences. So we would have to retry, you know, all of those if you're not doing harm review and you're allowing these to be raised under 3800A.
Even under 3800A, there is harmless error review. I mean, we've said that.
Yeah, so what you said in plot was remand to the district court to do fundamental error review. There's sort of a question after Monago about whether a trial court could do harmless error review under 3800A. We think they probably can because they're sitting in review of what a prior court did. But in Monago, you know, the court did say that a trial court, at least in the sort of direct appeal, you know, resentencing context, could not do its own harm review. But I think we trust that the trial court could here. But still, I mean, we're talking about 7,100 cases flooding the system where judges have to expend their
if there's
resources.
a constitutional error, there'd be a constitutional error. And I don't know if we could ignore, you know, a constitutionally required remedy just because the bulk of defendants that it would affect. But on harmless error, I asked your friend on the other side if he could think of any other illegal sentences that were subject to harmless error review. I have the same question for you.
So it's possible. I'd want to spend some more time thinking about that. But you could imagine a case where there's a you know, there's a min-man imposed by the statute, and so the judge didn't have to sort of like think too hard about what sentence he or she was going to impose for that defendant. It had to be 15 years. And so you're taking that off the table. and then there's a potentially a remand. But it may have been that the judge had to grapple with that sentence, would have said that 15 was appropriate anyways. So you might even have to do harm review like in a circumstance like this. So it's not, I don't even think it's quite as simple as my friend is suggesting, that, well, you wouldn't even do harm review if this statute was facially unconstitutional in all respects and couldn't be applied at all. So even if he could get past the severability hurdle, harm might still apply, because it could have been that this judge would have looked at this and said, of course I'm giving you a life sentence, which he could have, without the min-man.
But just to clarify Justice Sasso's question, there's no other thing where we've said or indicated that under a 3.800A illegal sentence analysis there is harmless error review.
Yeah, Justice Grosshans, I'm not aware of that. They all tend to be things that it's pretty clear cut. You exceeded the stat max. You couldn't have resentenced in violation of double jeopardy. Things where the error is structural. So I think that as a rule probably makes a lot of sense, because, and the reason that I was offering the point about the 7,100 inmates is when the court adopted the rule, I think it sort of had this situation in mind of the protection of the state's finality interests. So the court did away with the 2-year statute of limitations, or didn't insist on a limitations period like in 3850, but the trade-off is you have a very narrow definition of an illegal sentence. Are there any additional questions that I can answer? Thank you for your time.
Thank you.
May it please the court. Initially, I think it's unfair to talk about the 20 years later. I think this rule has been clear since Apprendi and the legislature and the courts have been slow to address it. So I don't think that should be held against a criminal defendant when the right was recognized in the year 2000, and here we are in 2025, finally applying it correctly, and the U.S. Supreme Court is essentially telling the entire country, we've said this over and over again, the downright tedium, and you guys aren't getting it. So I don't think it's fair to put the delay onto the defendant. Additionally, the retroactivity issue, Mosley explicitly says, as a matter of fundamental fairness and an application of the Witt test, that they're going to apply Hearst retroactively, and they apply it since Ring from 2002, when Ring initially would have rendered the Florida statute unconstitutional if the Florida Supreme Court had acted appropriately, or if someone had made a decision. But they said, as of 2002, the statute was unconstitutional. So our position is, as of 2000, the statute was unconstitutional. And Mosley specifically applies a right to a trial by jury, Sixth Amendment claim, retroactively. So there's a conflict between Mosley and the case we discussed earlier. And I would suggest that Mosley is more in keeping with the current opinion of the U.S. Supreme Court in Erlinger. And the Dettel case explicitly says it's comparing a double jeopardy analysis on appeal, and it says that's not retroactive because that's a procedural mechanism by the appellate court. It compares it to the right to a jury trial, and they say that that has a substantive character because it talks about what the state must do to prove its case beyond a reasonable doubt. So again, it's our position, the statute's unconstitutional on its face. You don't do harmless error review if the statute's invalid. It's just invalid. It doesn't apply. You then return to the statutes that are the valid statutes that remain, and the state's correct that the judge could impose a life sentence, but he gets de novo sentencing pursuant to the Criminal Punishment Code because the PRR statute says he doesn't get a sentence pursuant to the guidelines. Now he gets a sentence, and the judge gets to exercise his discretion to impose a sentence between 67 months and life. So the judge then gets to decide whether this particular defendant, his conduct and his history and characteristics justifies a life sentence or something smaller. So, but we think the clear indication of Erlinger, it's our position that Erlinger actually says that this is what the Sixth Amendment meant from the time it was enacted. So we would suggest it should go back to everyone, but at the very least, to Apprendi when this right was explicitly recognized by the U.S. Supreme Court. Thank you.
Thank you. We'll be in recess for 10 minutes.
All rise.